Good evening and welcome to the City of Cedar Falls Planning and Zoning Commission meeting for this Wednesday, February 26th, 2020. And Ms. Howard, could we have the roll call?
Atkins, Hartley, Holst,
Here.
Larson,
Here.
Leeper,
Here.
Lynch,
Here.
Prideaux,
Here.
Saul,
Here.
Wingert. Note that we have 3 members absent tonight.
All right, thank you very much. I guess our first item of business is the approval of the minutes from the February 12th, 2020 Planning and Zoning Commission meeting. Do we have a motion or any corrections?
Move to approve.
Is there a second?
Second.
All in favor signify by aye.
Aye.
That motion carries. At this time, I would open up the floor to anybody who is here who would like to make a public comment to the commission on anything that's not on the agenda. Seeing none, I'll close the public comments and we'll move on to new business. We have no old business. And under the new business, we have only one item, and that's a special commission and board training on conflicts of interest and ex parte communication. Do you want to introduce Karen?
Today we have Christine Stone from Allers and Cooney Attorneys here to give you a little training on on conflicts of interest and ex parte communication. Thank you, Christine.
Thank you. Good afternoon. Yes, my name's Christine Stone. I'm a shareholder at the Allers and Cooney Law Firm in Des Moines. Prior to coming to our firm, I was an in-house city attorney and an assistant city attorney before that, so I've been practicing municipal law in the state of Iowa for 10 plus years now. I was asked to come and visit with you all tonight about sort of your role, what Iowa law says about that, conflicts of interest, ex parte communications, and I'm also going to talk just briefly a bit about some open meetings topics as well. So in terms of the big picture, the Planning and Zoning Commission and Board of Adjustment are created by statute, the Iowa Code, Chapter 414. Iowa statutes reference the commission and the board, so you basically take action as a body. It's not any individual member who is empowered under Iowa law to take action. It is yourselves collectively who act as a group. The Planning and Zoning Commission shall have and possess the following powers and duties. This is included in your city code, so it's further sort of refined within that document what you have the ability to do. Your powers include the preparation of the comprehensive plan, any other plans that relate to the comp plan, and any amendments to these plans. You review plats and vacations of city property. You also review plans for streets, parks, and other public improvements affecting the city. Cedar Falls also similarly identifies the powers of the Zoning Board of Adjustment. The Board of Adjustment has the following powers and duties under your code. In appropriate cases, to make special exceptions, to hear and decide appeals from decisions made by the Department of Development Services, to authorize variances, where, owing to special conditions, a literal enforcement in the provisions of the chapter will result in unnecessary hardship. So unnecessary hardship is sort of a term of art that's defined under Iowa law. The sort of elements of that are the land in question cannot yield a reasonable return if it's used only for the purposes allowed in that zone. The plight of the landowner has to be due to the unique circumstances and not to general conditions in the neighborhood. And the use to be authorized cannot alter the essential character of the locality. So you couldn't grant any variance that is just completely out of character for the neighborhood. So essentially the big picture for you folks is your authority and powers come from actions that are taken as part of the board or commission to which you are a member, not any of your actions as an individual, and this framework comes from both state and local law. Okay, I realize this is not the presentation that I sent to Kevin, so I am going to get my flash drive. very similar, but
Should be, is there one right here?
yeah. Updated it. This is the last time I was here. So I apologize. Okay, we can skip ahead to some of these because a lot of it is consistent with what I presented, but. Okay, so here's some new information that I recall adding. So again, as we said, your authority comes from actions taken as a whole, and the thing that's important to remember about that is that you do not have individual authority. So anything that you are out there doing sort of on your own is really unauthorized by Iowa law. And there is case law out there that says that if a city officer acts in bad faith or knowingly exceeds his authority, you can be held personally liable for that. So that is why it's always very important to remember, you know, I'm a member of this body. Personally, I can't be talking to developers or anybody out there and, you know, making promises or what have you. It's really as the group that you retain your power and authority under Iowa law. And when you do act within your authority, Iowa code is very clear that the city has an obligation to indemnify you and defend you in those actions. So it's just important to keep that in mind to protect yourselves and the city. So that is sort of the big picture. Does anybody have any questions about that and your role?
I do also want to acknowledge we have members of the Board of Adjustment and the Board of Rental Housing Appeals here tonight, so they're all here to hear and just open it up for questions too from those folks.
And so any appointed office within the city, you're considered a city officer. So anything that would apply to a Planning and Zoning Commission member as a city officer would also apply to a Board of Adjustment member, any other sort of appointed position on a city board or commission. So this information does carry over to those other positions as well. So the bulk of tonight's information is going to talk about conflicts of interest. Conflicts of interest are defined in the common law, which is sort of cases that have been litigated over the years and what those court decisions say. There is some statutory information in Iowa Code Chapter 362, as well as Iowa Code Chapter 68B. And then you also have your own sort of internal city policies that you have to keep in mind in addition to Iowa law. So under the common law, the sort of seminal case in Iowa is Wilson versus Iowa City. And in that case, the Iowa Supreme Court has stated that conflict of interest rules, whether common law or statutory, are based on the principles of are based on moral principles and public policy. They demand complete loyalty to the public and seek to avoid subjecting a public servant to the difficult and often insoluble task of deciding between public duty and private advantage. So it's that conflict, you know, between your public role and then your private interests or advantage that can be sort of competing with one another. It is not necessary that the advantage be a financial one. Neither is it required that there be a showing that the official sought or gained such a result. It is the potential for conflict of interest that the law desires to avoid. So even if, you know, it doesn't result in an actual conflict, if there is the appearance of a conflict, that can still be something that's prohibited under Iowa law, which you should all be sort of cognizant of. It is generally improper and illegal for a member of a municipal council or a similar body to vote on any question in which he is personally interested or where his personal rights might be affected. And under the common law, a conflict of interest can also be found where a policymaker, which would be you folks, you are making policy decisions on behalf of the city, has an unalterably closed mind on matters that are critical to the disposition of the proceeding. You are required to consider in good faith, to objectively evaluate the arguments that are presented to you, but you're not expected to be subjectively impartial. So you do come to your role on behalf of the city with your own experience, your own history, your own opinions, and that is totally fine, but you are required to keep an open mind when matters are presented to you for your consideration. Board and commission members must therefore remain willing to consider opposing views on items which come to them for consideration. You should be aware of potential conflicts and identify or disclose them in advance. The city attorney is an excellent resource if you feel like something's coming down the chute where, you're feeling a little uncomfortable or you might have a potential conflict. It's important that you seek guidance early. Rarely are the issues black and white. There usually has to be some discussion and, fleshing out of, okay, well, what are the potentials here, and what should the best course of action be. So moving on to the statutes, Iowa Code Chapter 362 includes a provision that says a city officer shall not have an interest, direct or indirect, in any contract or job of work or material or the profits thereof or services to be furnished or performed for the officer's city. A contract entered into in violation of this section is void. So that is a pretty broad statement. So any sort of transaction involving the city with you on the other side, that's really a conflict of interest, and that's what Chapter 362 is dealing with. And generally, I call these a self-dealing conflict because basically, you're a representative of the city and you're on the other side of the table. You're really on both sides of the table in that sort of an arrangement. There are exceptions to this prohibition. There's quite a few exceptions under the statute. I've just listed sort of the most common ones that we see. So any contracts that are publicly bid, if it's a sealed, closed bidding process that maybe your company is, submitting to the city, that would not be a prohibited conflict. Contracts that predate the election of the officer, so if someone had, worked in the private sector and had a contract that was entered into with the city and then runs for public office after that, that's sort of accepted out. Contracts where it's with your employer, but you have less than a 5% ownership interest in that company, then it's not a conflict. And then there are others also, but like I said, those are usually the most common ones that we see. It's important to know that Iowa Code Section 721.11 makes it a serious misdemeanor to have a direct or indirect interest in any contract to furnish anything of value to the city. So these types of conflicts, depending upon the severity, can constitute a crime. Serious misdemeanors are punishable by a fine and imprisonment of up to a year. So that is always something to be aware of. The next section in the Iowa Code gives the members of a board or commission the ability to determine whether a conflict exists for yourselves, and this determination is considered conclusive. So if something is coming before you folks and you feel like you have a conflict and you express that at the meeting and say, I'm going to abstain due to a conflict of interest, that's a conclusive determination, and nobody can really, force you to vote once you make that decision for yourself. And the other sort of safety net in these cases is, let's say you do have a conflict, you don't realize it at the time. Even if you do vote on a matter, that matter's not going to be sort of dissolved unless your vote was decisive to the passage of the item. So if you, had the decisive vote, then that's a problem. But if there was more than, just a one vote difference, it would not. But recall that a contract is considered void where you have a prohibited interest in that contract. So even if the action of the board is upheld, the contract itself could be determined to be void depending on the circumstances. Turning to Iowa Code Chapter 68B, And commission members are prohibited from engaging in any of the following conduct. There are 3 categories in this statute. The first is outside employment or activities that involve the use of the government's time or resources to give the person an advantage or benefit that's not available to the general public. The second is outside employment or activities that involve the receipt of consideration by the official from someone other than the government for performing work that is part of your official duties on behalf of the government. And the last one is outside employment or activities that are subject to the official enforcement or control of the person during the performance of their official duties. So here are some examples to try to help explain what that means. The first category would be like if the city gave you an iPad for city business. If you use that iPad then to run, an online store or something like that, you're using the resources of the city to benefit yourself. This is something that's not available to the public, so that's considered a conflict of interest. The second one might be, as an example, accepting payment from a home builder each time you recommend approval of a residential subdivision plat for them. That's receipt of consideration from someone other than the government for performing work that is part of your official duties. And then the third one would be, if you yourself work as a residential home builder within the jurisdiction where you also serve on the ZBA. That would be employment that is subject to the official control of your government position. So for each of these conflicts, there's sort of a different way you have to deal with them. For conflicts 1 and 2, you have to immediately stop the outside employment or activity. But for conflict number 3, you can either stop it or you can publicly disclose the conflict and avoid taking action that would detrimentally affect or create a benefit for that outside employment or activity. So here again, it's real important that you sort of discuss these things in advance and understand what's the appropriate way to handle it. Do you absolutely have to stop? Do you just have to announce it and not take any action? Because different conflicts are going to have different ways to resolve them. Iowa Code Chapter 68B also extends certain conflicts of interest to your immediate family members. An immediate family member under Iowa law, however, is defined as the spouse and any dependent children of a public official or a public employee. So if you have adult children, that's not a conflict. It's just spouse and dependent children. So if you are prohibited from doing something under the statutes, so are your spouse and dependent children. Iowa Code Chapter 414 also has sort of a conflict of interest related provision. This talks about the Board of Adjustment and says that a majority of the members of the Board of Adjustment have to be persons representing the public at large and cannot be involved in the business of purchasing or selling real estate. And that's clearly to avoid conflicts of interest on that board. The City of Cedar Falls does have its own internal policy on conflicts. There's an annual declaration that's required. The city prohibits its officials from engaging in any activity, practice, or act that unlawfully conflicts with or appears to conflict with the interests of the city. And as we discussed, this is consistent with this Wilson versus Iowa City case. It's the potential for a conflict of interest that the law is seeking to avoid. So whenever in doubt, disclose the potential conflict and don't take action on the matter. This includes discussion. Some people think, well, if I just don't vote, that's fine. But you also shouldn't be trying to influence any of the other board or commission members if you have a conflict. And I did want to discuss one Iowa Supreme Court case that specifically talks about conflicts of interest on it's a county board of adjustment, but the same principles would apply to a city. And in this case, this was Pottawatomie County. There was a person who had come to the Board of Adjustment seeking basically it was a special use permit to put in a landfill. And they challenged the action of the board. The board ultimately turned it down. And they challenged the action of the board, claiming that several of the board members had conflicts of interest. The types of conflicts of interest that were alleged, 2 of them were insurance agents, and they said, well, people that you sell your policies to are opposed to this, so that makes you opposed to it. You're conflicted. Someone else had an employer who, a member of his board, was vocally opposed to the project, and they said, well, that's a conflict. And then there was another one who had a son that worked for a nearby city who had opposed the project. The Iowa Supreme Court considered those types of conflicts and said they were not prohibited conflicts of interest. They were too sort of tangential to the issue involved. Really, you have to be able to show that there is a direct, definite, capable of demonstration, not remote, or merely speculative conflict. So it has to be something concrete. And the most common ones that you'll see in the case law has to do with financial gain. So if somebody is clearly financially tied to a project, that is absolutely a conflict. And then also if you own property that's nearby for these types of conflicts, that would clearly be a conflict. But, you know, just having a friend or a family member who might be opposed to a project is not going to be sufficient. So any questions about conflicts of interest? Okay. Moving on to ex parte communications. We really are talking about due process rights when we talk about ex parte communications. Due process requires fundamental fairness in a judicial proceeding. A trial that is fundamentally unfair violates the guarantees of due process under the U.S. and Iowa constitutions. So as an example, when you think about a trial, when a lawyer for one party communicates sort of secretively with the judge or a juror involved in the case in a manner that is, attempting to influence the outcome, the other party has really been deprived of their due process because they were not a party to that discussion. They didn't hear what was discussed. They didn't have an opportunity to respond to it. And the confidence of the public in the impartiality of the tribunal can be compromised. The Iowa Supreme Court has explained the purpose behind the rule prohibiting ex parte communications is to prevent the effect or even the appearance of granting undue advantage to one party to the litigation. These same principles apply to situations where a city board or commission is performing a quasi-judicial function. Quasi-judicial functions are found where the activity involves proceedings in which notice and an opportunity to be heard are required, or where there is a determination of the rights of the parties, which requires the exercise of discretion in finding facts and applying the law thereto. So what does that mean? Quasi-judicial proceedings would be PUD rezonings. Those usually involve very specific criteria that are applied to a specific piece of property. Variance requests, pretty much anything that the Board of Adjustment considers is quasi-judicial, and then any and all appeals that would come before you are quasi-judicial. Just rezonings in general, in most cases they're considered legislative in character, so they are not quasi-judicial determinations. But PUD rezonings are, if you have design standards that you're applying and sort of analyzing, and any other situation where the commission or council is called upon to review an interpretation and application of an ordinance. It can be difficult to draw this line, so in many cases the best course of action is just to avoid ex parte communication if you can. I know sometimes you cannot, but that would be the preference. At a minimum, due process requires that quasi-judicial proceedings involve notice, an opportunity to be heard, and an impartial decision maker. Ex parte communications can lead to one party being heard more than the other and/or can lead to a biased decision maker, and both of which would violate the due process rights of the parties involved in the matter. There is guidance from your city attorney from 2007, which is an excellent summary of these concerns and issues. If you don't have a copy of that, I'm sure you can obtain one from your current city attorney. Ex parte communications should absolutely be avoided in quasi-judicial proceedings. And if such communications occur, they should be publicly disclosed at the meeting to give the parties an opportunity to respond or object or raise additional information for the board or commission to consider. So everybody gets to hear what was discussed and what the board is basing its decision on, basically. Okay. Any questions on that topic?
Yes, I have one.
Sure.
Sometimes when we have things coming before us, I like to drive out and look at the project. I was kind of told I shouldn't do that. Tell me about that.
So, sort of the same due process issues that we've talked about, when, as a board, you're making a decision, it's important that you all are sort of operating with the same information. So when you have a public hearing, that's the opportunity for people to present information to you. If you're going out and seeking additional information on your own that the other board members don't have, and that nobody has brought to your attention, then you sort of have these outside influences when you're making your decision. So really, you should base your decisions on the information that's presented at the public hearing. And that way, everybody's receiving the same information. The people who are coming and presenting information to you know that that's what you're basing your decision on, not outside things that you've sought out on your own.
So if I go drive by a project, I need to disclose that. Not that I'm talking to anybody, I'm just driving by and looking. I like to see the lay of the land
Yeah.
and what's going on.
I mean, I would say you should say that at the meeting and say, to
Okay.
better understand this issue, I went out and visited, this is what I saw, this is what I think about it. And at least everybody then is on the same page and understands that that's part of your decision making. But yeah, the best practice is just base your decisions on what's presented at the public hearing.
All right, thank you.
Uh-huh. Anybody else? Yes.
You mentioned this body hears a lot of cases that are site plans
Mhm.
and also subdivisions. Both of those, I assume, are both quasi-judicial in nature.
They are, because you're really applying the standards of your ordinance to a specific piece of property and sort of interpreting, what the ordinance requires. Are they meeting those standards? So yes, those would be quasi-judicial decisions.
So can you give me an example of something that is not, just so I can have that frame of reference?
So just a general rezoning request is a legislative decision. You're making that decision on behalf of the entire city, and does this fit here for our community? That's more of a policy legislative decision.
Yeah.
Quasi-judicial is, when you're really focusing on a specific issue, property, interpreting your ordinance, considering the rights of individual parties. Those are more quasi-judicial.
What if it's an individual property, one property that's being rezoned at the request of the property owner?
It's still, the cases in Iowa say that that's still a legislative decision, because the board is really considering, the comprehensive plan, the community as a whole. These are the types of uses that we as a community have decided are appropriate here. So those are more legislative type considerations.
The other thing this body would hear would be amendments to the zoning ordinance, and that would be legislative.
Yes. Because then you're considering revisions to your code. So the law, yep. Okay, the last topic I wanted to cover is open meetings. Anytime I meet with a public body, I think it's important to sort of do a refresher on open meetings. Iowa Code Chapter 21 includes an intent provision. This chapter seeks to assure through a requirement of open meetings of governmental bodies that the basis and rationale of decisions, as well as those decisions themselves, are easily accessible to the people. So again, this all ties together. Public hearings, only considering the information that's presented to you in the public meeting, avoiding, outside ex parte communications. It all goes to the intent of sort of open and accessible government. Any ambiguity in the construction or application of the chapter should be resolved in favor of openness. So there is a clear, desire to have open government, where your deliberations and decisions are subject to public scrutiny. The open meetings law is to be liberally construed. Its purpose is to prohibit secret meetings and to require such meetings to be open and to allow the public to be present. So the first question whenever you're dealing with an open meeting is, what is a meeting? A meeting is a gathering in person or by electronic means, formal or informal, of a majority of the members of a governmental body where there is deliberation or action upon any matter within the scope of your policy-making duties. Meetings do not include a gathering of members for purely ministerial or social purposes when there is no discussion of policy or no intent to avoid the purposes of this chapter. So again, a meeting is the gathering of a majority of the members where there's deliberation on your policy-making duties. P&Z and the Board of Adjustment are both clearly governmental bodies under Iowa law. So where both answers are yes, you're a governmental body, it's a meeting, then you have to follow the open meetings requirements. And so what are those requirements? You are required to proceed your meeting with, the meeting has to be preceded by public notice, has to be held in open session unless a closed session is expressly permitted by law. All actions and discussions have to be conducted and executed in open session, and each body has to keep minutes of all of its meetings. You are required to give notice of the time, date, and place of your meetings and the tentative agenda in a manner that's reasonably calculated to apprise the public of that information. So what does that mean? You know, that means your agenda, when somebody reads it, they should be able to somewhat understand what it is that you're going to be acting on. So many times I tell folks, you know, even if a legal description is required, you should still also probably give an address so that people know, oh, okay, I know where this is. Most people don't understand legal descriptions. Notice should be posted on a bulletin board or other prominent place, which is easily accessible to the public. And the notice has to be provided to any news media who have requested such information. Notice must be given at least 24 hours in advance. Unless for good cause, such notice is impossible or impractical. But in that case, as much notice as is reasonably possible must be given. So if there's some emergency reason why you couldn't give 24-hour notice at the start of your meeting, you should announce why that was and how much notice you were able to give. Minutes for your meetings have to show the time, date, place, and members present. They must show the results of each vote taken. They have to include sufficient information to indicate the vote of each member at the meeting. All votes are required to be made public in open session, and therefore voting by secret ballot is prohibited. There was an Iowa Supreme Court opinion in 2016 that dealt with the open meetings law. It involved a possible open meetings violation where the county administrator met with county supervisors individually in order to formulate a personnel restructuring plan. And essentially what the court said in that case was a meeting can occur where there is less than a majority of the body physically present, but where a majority is being represented by an agent or proxy. These can be referred to as serial meetings. So if you know, the county administrator meeting with each board member individually and sort of sharing information back and forth to come up with a plan. So be very cautious when you're meeting with individual board or commission members or small groups of board or commission members. You shouldn't share what other board or commission members have said or how they plan to vote on an item. You know, sometimes small meetings are very helpful because you can you know, receive more detailed information about things where you don't want to take up time. But really those sort of meetings, if it's coming from the city or the staff, it should really be really one-sided. It should just be receiving information, not deliberating, not talking about how you're going to vote on something. They should just be informational meetings. Under Chapter 21, there are some rules of conduct. The public is entitled to use cameras or recording devices at open meetings, so you can't ask someone to put away their phone or their camera if they're recording you. But nothing in Chapter 21 prevents a governmental body from making and enforcing reasonable rules for the conduct of your meetings to make sure that they are orderly and free from interference or interruption by spectators. So if people are, absolutely disrupting the meeting, it's fine to deal with that, but they can record. Penalties for violations of open meetings rules. Damages can be assessed against anyone who participated in the meeting unless you can claim a valid defense. The penalty can be up to $2,500 in certain circumstances. Attorney fees are also available under open meetings cases, and if you were participated in the violation, those can be taxed against you personally. Or if there's a valid defense, then it can be taxed by the government itself. And one of the most important defenses is if you have a written legal opinion from an attorney on behalf of the city. So if there's something that you're not sure that you could, go into closed session on, if you ask the city attorney, can you give us a legal opinion? Is this appropriate for us to go into closed session to discuss this topic? That is a valid defense if then somebody claims you did it unlawfully. Other potential penalties, actions that were taken by the body in violation of the law could be voided. A member can be removed from their position if there was a prior violation of the open meetings law, and there can be an injunction against any further violations of the law. Ignorance of the law is not a defense, so it's important to sort of be aware and keep these issues in mind. And that was all I had prepared. If there are additional questions, I'm happy to answer those.
Any questions for Christine?
Christine, what are some common problems you see in these, most common problems?
With conflicts or?
Just generally by boards like this.
I think conflicts come up a lot, and I say that because usually folks like yourselves are usually pretty involved in your community. You usually, lots of times you might be business owners, you might be on other boards or play a prominent role, and so sometimes those things can overlap, and that can, cause issues. So that's why I just always tell people, make sure you're aware of that. Go in and talk to the city attorney and say, hey, I'm on this board, I'm on, I volunteer here, these are other issues. So if anything comes up involving these entities, let me know because I potentially have a conflict. So just being aware and staying on top of those things, I think, can help a lot. Because unfortunately, sometimes we don't hear about it until, it's too late to do something about it. And then it's, okay, well, now what do we do? So.
Great. Well,
Questions from the Board of Adjustment, Board of Rental Housing Appeals?
No. All right. Well, thank you all very much for your attention.
Thank you.
Thank you.
thank you, Christine.
My email and Kevin has my phone number. You're welcome to call if anything ever does come up and you have additional questions. So.
Well, having been on the commission for a long time, my general rule is I think it's close to being anything, I'm just going to abstain.
Yeah.
It's just not worth the potential.
Yep,
fallout.
I agree. That's a good practice.
All right, well, that's completes our business for tonight. Is there any commission updates, Karen?
Just a couple of things on the upcoming meetings. Just want to make you aware that we are starting that process with the Imagine College Hill. So if you want to get it on your calendars, the design review, the design charrette is coming up for College Hill at the end of March. The big public meeting would be on that Saturday, March 28th. We hope that Commission commission members feel welcome to come. It's good to participate and kind of hear what the community has to say. So we're hoping for good participation in that. And then, of course, the week following that big public meeting will be the opportunity for people to stop into a design studio, which will going to be set up in this case at the Hearst Center, where the consultant team will be working, and people were just like similar to downtown. People can drop in and see what's going on, ask questions, provide additional feedback throughout the week. And at the end of that design review, or excuse me, design charrette, there will be a public report out from the consultants on what they heard from the public and the work that they've done for the week. And that should be quite enlightening as well. So that will be Thursday evening, April 2nd. They'll be presenting the report out from the charrette. So
Do you have the time for the charrette on March 28th?
on March 28th will be in the morning
Okay.
from 9 to noon, Saturday morning.
Great.
And then we also have coming up fairly soon, we'll be reviewing the downtown, updates to the downtown zoning code. And so just want to give you a heads up about that. That's coming soon, and that should be kind of an exciting thing. And we'll dig into some details of the code. The consultants will be here to then present a public review draft, and then that will be made available for the public for a good period of time for everybody to take a review of that. And then, of course, we'll have public hearings in front of you and also the city council for that code update.
Great. Well, some exciting times coming.
Okay.
So, if there's nothing else, I'd entertain a motion to adjourn.
So moved.
Second.
All in favor signify by aye.
Aye.
We are adjourned. Thank you very much.